Hey everybody, Jordan on Justice here. Today we're going to do a deep dive into one of my favorite movies of all time that just happens to involve the law, which is Liar, Liar, a movie where Jim Carrey plays a lawyer and a father who's struggling to manage his work and life and balancing it appropriately. So let's jump in.
My mom's a teacher.
And your dad?
My dad, he's a liar.
A liar? Oh, I'm sure you don't mean a liar.
Well, he wears a suit and goes to court and talks to the judge.
Oh, I see. You mean he's a lawyer?
It's a cute scene, and as a father and lawyer myself, my daughter's 9, my son is now 5, almost 6, that scene resonates with me a little bit because I wonder what explanation my kids would give to their teacher in school if they asked, but fortunately I think they'd just say lawyer. Anyway, it's a cute scene. The whole premise of this movie, obviously, is that there's a lawyer who's got a pattern or habitualization of lying, which is a problem, so we'll see more of that play out throughout the movie here.
Max! Hi, Greta.
Hey, what's new?
Well, it's my birthday tomorrow and we're having a party and everything.
Wow! I am sure that your daddy has got you something wonderful.
Yeah?
Yeah, you bet! Listen, kiddo, why don't you go play in my office for a minute? Sue somebody for everything they got. Maybe you can send a fax to one of your girlfriends. Hey, sorry. Damn it! I completely forgot.
Oh, what a surprise.
You are a saint. I should buy you a gift.
You did.
I always do the classy thing. Any calls?
Judge Rawlings' clerk, he needs your filing.
Tell him it's in the mail.
Right, she'll do it next week. Mr. McKinley phoned to confirm your meeting tomorrow.
Strep throat. No, some kind of virus. What's going around?
Asian flu.
Good one.
And your mother called.
On vacation.
It's your 5th week.
Snowed in. Phones are down.
Break mother's heart. Done. No, that's it. Except Miranda's looking for you.
Ah, how much ass do I have to kiss to make partner in this damn place?
I think what this scene does a good job of depicting is the significant role that paralegals and legal assistants play. But obviously in this scene, it's almost less about the legal work and more about managing the lawyer's life. And I think that's a line that's probably drawn differently from firm to firm. In our firm, our paralegals and legal assistants, they are irreplaceable. They make all the difference in the world, adding value to our clients' cases, giving them the best experience from a customer service standpoint, and honestly helping us lawyers stay on top of critical deadlines. In this scene, it's a child's birthday. Thankfully, none of the lawyers here have to worry about that. We're all good enough being able to manage our own personal lives in that way. But I think what this scene is actually trying to portray, even in a comedic sense, is somewhat accurate. Lawyers struggle with work-life balance all the time, especially those doing litigation. It can be really, really challenging to manage all the deadlines that are demanded of you from other lawyers, discovery, deadlines, the court, and then even your own life. So paralegals do play a critical role in that regard.
Mrs. Cole, the only problem here is that after you've provided years of faithful service and loving support of raising his children, they are his?
Huh? Oh, yeah. One for sure.
After all that, your husband wants to deny you a fair share of the marital assets based on one single act of indiscretion.
7.
Pardon me?
7 single acts of indiscretion.
7 acts of indiscretion, only one of which he has any evidence of, and all of which he himself is responsible for.
So listen, this is a scene where you basically have a lawyer pitching a client on why they feel like they can best serve their needs and asking that client essentially to trust the lawyer enough to represent them. Now, I've never done family law. This is coming up in the context of a divorce, so I can't speak to that. But I think what does ring true is lawyers really try at times to sell the client on what they feel like they can do to add value. At the end of the day, people can Google lawyers and find them a dime a dozen, it feels like, but everybody's different. Everybody brings their own unique life experience, their own education, their own training, and their own strategic vantage points. Now, in this particular case, Jim Carrey, I think, is going a little aggressive in trying to almost cross the line between giving the client a false impression that the outcome is kind of determined. You never want to get too close to that. I try and tell clients all the time, I don't have a crystal ball. I can't promise anything except that I'll leave no stone unturned. We'll be as creative as we need to be. Now, another big takeaway here is trying to use the consultation as an opportunity to interview your client to find out not just a little bit about them, but all the potential damaging facts that could hurt their case. At the end of the day, we're advocates. Our duty is to zealously advocate, and there is no case that's quote-unquote perfect. I don't even know what that means. But in my case, bad facts might be a prior accident or prior medical treatment to the neck or back that were now being complained of after this traumatic incident. So these things are not case killers, but they're things you want to be aware of so that you don't step on a landmine by giving inaccurate discovery answers in depositions or interrogatories.
Oh, you are good. You are very, very good. You know, the cold case is worth a truckload of money to this firm. If you win, I guarantee you'll make partner. Oh. In fact, how would you like to make a partner right now?
Oh,
I guess what you've got here is a quid pro quo. This is the senior partner telling someone, I guess as an associate, aspiring to be a partner, if we can get this case, and if you win it, I guarantee you an elevation in employment status. I don't know anything about that because that's not how our firm operates, and we don't ever put those kinds of demands or expectations on our associates. In fact, we try not to be too results-oriented because at the end of the day, what I care about is that our associates are giving clients their best opportunities to succeed. I can never know what a judge or jury is going to do, and if I judged every associate by every ruling or verdict, that wouldn't be a fair thing.
Dana!
All right, Samantha. How much will it take to put an end to all this?
50% of your estate.
50%? With a prenup and proof of adultery? What's your case?
This is the proverbial courthouse steps, although here it's inside the courtroom, but it's this notion that at the last minute, right before the trial or final hearing takes place, both sides come together and try and resolve the case. There is some truth to that generally, but there's no universal truth. Sometimes that'll happen, sometimes it won't. Sometimes you're so far apart, it'll never be worthwhile even pursuing. But I think what's wrong about how they paint this picture here is, again, I haven't done family law, but in every civil dispute that I'm involved with, there are fixed landmarks throughout the litigation, like mediation, where you come together specifically for the purpose of trying to resolve the case. And so this leaves me with the impression, probably the false one, that this is the very first time they're broaching the idea of settlement. The other thing that's inaccurate is you've got the client, in this case the husband, kind of talking to the other party or client. For the other side, what will it take to settle? Typically lawyers are doing the negotiation without their clients there. There's a lot of good reasons for that, but ultimately it's the client's decision on what's an appropriate settlement offer.
Our case is simply this.
Very funny, Fletcher. You want to play hardball? I'm game.
You want to play hardball? I'm game.
You know, obviously this is a ridiculous, nonsensical scene, but I have to tell you, out of all of the most ridiculous things in this movie, there's a kernel of truth in this. There are sometimes, in some cases, I look to the person on the other side, the defense lawyer, and I said, I don't understand your position. You're basically giving us a lowball offer, but we have clear liability against your client or clients, and a really good chance of hitting this thing out of the park at trial. Your offer doesn't match the risk management that I would anticipate someone in your position and the insurer to do. And I swear so many times I asked them, like, what am I missing? Tell me what I'm missing so I can go back and tell my client. And it just feels like bullshit, or they've got nothing. They're just going through the motions.
First, Mr. Reed, I see where your client...
Your Honor, I would like a continuance.
This case has already been delayed several times, Mr. Reed.
I realize that, Your Honor, but I would really like a continuance.
I'll have to hear good cause, Consul. What's the problem?
I can't lie!
Commendable, Mr. Reed, but I'm still waiting to hear good cause. Now, do you have one or not?
Not!
Motion for continuance denied.
All right. This is a humorous scene, but again, there's some kernels of truth here. So in Florida, for example, when you move for a continuance, more often than not, you're going to need to show good cause. And good cause is not just how you use it in everyday language. Good cause is a legal term of art. Okay, so you can't just walk in and say, it would be convenient, I'd prefer it, I'd like more time. You need to have a legitimate excuse. The other thing here, though, that's a little different is in Florida, for example, motions for continuance have to be given in writing. You can't just move for them orally, and the client has to sign a consent form there. So obviously this case doesn't take place in Florida. It's family court, not personal injury, but those are a little bit of differences. And I do think what this movie captures really nicely is a judge's disposition. He hears a motion being made, in this case or tennis orally, and he's trying to entertain it, but he's saying, hey, here's the legal standard. Give me the information I need to determine if there's good cause. He doesn't get it in a pretty comical manner, and so he properly denies the motion.
Is there any chance of a settlement in this case?
I don't think so, Your Honor. My client has already offered Mrs. Cole $2.4 million, but Mr. Reed has made it abundantly clear that he has no desire...
Settle! Settle, 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 settle!
I don't want to settle, Mr. Reed. You convinced me yesterday. I'm the victim here. I'm starved for affection. I'm driven into the arms of another man.
7.
Yeah, whatever. With the story you came up with, I don't think we can lose. I want to proceed.
Mrs. Cole, don't understand.
Mr. Reed, do we have a settlement?
No!
Settlement is a big topic of discussion in this country, and in my experience, more cases settle than not. And what we're seeing here is a judge on the eve of like a final hearing, or in our practice, on the eve of a trial, sometimes right while the prospective jurors are waiting outside, the judge will reinforce this notion one last time, is there any chance this case can settle? So that part is pretty realistic. What's unrealistic here is you've got one attorney saying, no, judge, I don't think so, though it's just, okay, it's good so far, and then telling them the terms of the last offer. We almost never involve the court. In fact, I've never involved the court with the specifics of what the actual offer and last counteroffer were. You generally just speak, I don't think we have a good chance, or we're close, maybe we could. So that's a little inaccurate. More alarming than anything else, though, is Jim Carrey, who's an agent for his client as a lawyer, accepting a settlement offer right there in open court, or at least trying to, without even consulting with his client and without having his client's authority. At the end of the day, the client is the master of his or her claim. If they want to settle it, they need to be presented with that information, and they need to tell you. You can't guess, you can't surmise, and you can't substitute your judgment as an attorney for that of the client.
Hello, Judge Stevens, hi! Fletcher Reed, I'm scheduled to be in your court in half an hour. Judge Stevens, I badly, badly need a continuance. Ill? Am I ill? That is the perfect question for you to ask. Please lie on for me.
What you're seeing here is something that should never take place. You're likely to lead yourself closer to disbarment than getting whatever relief Jim Carrey's character wanted here. This is an ex parte communication, which is when one party to a lawsuit is having a communication with a judge without the other side being present. This is a huge no-no. Typically, when you're sending anything or corresponding with the judge or the court, you're doing it in writing, you're copying the other side, you're typically putting it in a letter or an email, sending it to the judicial assistant, who's then giving it to the judge. You're not picking up the phone and literally getting the judge on the other end of it. So that's a big no-no.
Mr. Reed, several years ago, a friend of mine had a burglar on her roof. A burglar. He fell through the kitchen skylight, landed on a cutting board on a butcher's knife, cutting his leg. The burglar sued my friend. He sued my friend, and because of guys like you, he won. My friend had to pay the burglar $6,000. Is that justice?
No. I'd have got him 10.
It's hard for me not to laugh. Although Jim Carrey's character is predominantly a family law lawyer, apparently he does some personal injury work too, so this hits home. Look, this is basically an urban legend, and I've heard different versions of this over the years, even before I went to law school. This notion of somebody who's coming to criminalize somebody else's house, gets hurt, and then comes away with money in the end. There's no duty owed by a homeowner to that criminal, at least not under any recognizable doctrine that I'm aware of. It seems to me, as in my personal opinion, this is likely something that was made up by people from special interest groups like the insurance lobby to help further perpetrate this notion of tort reform, that there's runaway juries, jackpot justice, personal injury has gotten out of control. We don't take these cases. No lawyer I've ever met takes these cases. I've never even heard of these cases, and I just don't even think they exist.
The color of this pen is... The color of this pen is... The color of the pen that I hold in my hand is royal blue.
One of my favorite scenes of the movie, just probably because of how good of a comedic and physical actor Jim Carrey is. At the end of the day here's my takeaway. The name of this movie is Liar, Liar. This guy's clearly built a life, both personally and professionally, lying. I can't reconcile any of that with my own truth, but I can tell you this. Lying doesn't do anything. Even if somebody does it in a case and they maybe advance the ball a couple of yards, I've never seen them go all the way for a touchdown. Typically, what happens in the dark comes to the light and blows up in your face. So it's good, in my opinion, that Jim Carrey can't even lie to himself.
And Lupe, you keep those kids quiet. I'm not even close to kidding. Sorry. Billy threw up in the car.
You brought your kids to your divorce?
Sympathy.
Well, it's working. I feel sorry for them already.
This is a family court matter. Again, I don't have experience there, but what they're really trying to portray is a trial, because there are certain trials, bench trials they're called, where jurors don't decide it. I deal with situations where jurors are there. In any situation where you're asking someone to decide the outcome of a case, everything matters, even to how you present your appearance. We typically counsel all of our clients on how they dress, how they should present in court. In this example, should you bring your kids or not? All of these things are likely fleshed out well beforehand so that you present a clean and unified and professional-looking front to whomever you think is going to be making the decision.
Ms. Appleton, you may begin.
From March 6 through June 12, I surveilled Mrs. Cole at the behest of Mr. Cole. During that period, I noted that Mr. Cole left each day between 7:40 and 7:50. Thereafter, Mrs. Cole would frequently have a male visitor arrive and stay from 1 to 4 hours. I was able to take several photographs of the male visitor.
I see.
I can't even imagine any divorce proceeding having a full courtroom, by the way. I see really interesting personal injury lawsuits with jurors where the courtroom isn't even packed. Putting that aside, it's very common in civil lawsuits for one or both sides to hire investigators because lawyers are not witnesses. It's of no use almost for me to go visit every last scene, interview every last witness if I'm the only one that does it because I can't get on the stand and testify. So the use of investigators can be a tool for both sides. It's common. What we're seeing here at the very end, though, where the investigator basically handing the attorney who retained him a bunch of photographs, almost hinting that he should bring that in, a better trial lawyer would have had those pre-marked as exhibits and actually asked the investigator through a series of questions to lay the foundation and predicate, have those formally introduced into evidence, and then shown to the court.
Do you know what Mrs. Cole and her male visitor did during these frequent visits?
Well, they were pretty good about keeping the shades drawn, but I was able to make a recording of one such session.
Your Honor, as you are aware, under the terms of the prenuptial agreement, if Mrs. Cole commits adultery, she is entitled to nothing. With your permission, we'd like to play the following tape recording.
I don't want to take for granted this movie came out 25, almost 26 years ago. That's a cassette tape, and that's a device intended to play a cassette tape. When I grew up, those were still around, then it became CDs and MP3s, and now all that's long gone. But for those that don't know, that's what that is.
I'll cut it a little.
Come on! Your Honor! How can it be proved that the male voice on that tape is not Mr. Cole himself?
This scene always conveyed to me that Jim Carrey and his client had never heard this tape before. And I don't know if that's true or not, but if that's what they're trying to suggest, that's very inaccurate. In every civil dispute, both sides are entitled to discovery, which is the formal exchange of information, and without question, this audio tape would have been exchanged during discovery, or at least at the final stages right before trial with your exhibit exchange, so they would have been aware of it. And what Jim Carrey just stood up and did is basically present a legal objection, which almost certainly would have been handled in writing through a motion to eliminate before trial, or if nothing else, well before trial actually began in earnest. It wouldn't be done after the fact finder here, the judge, hears everything on the tape and then is being asked almost to disregard it for a legal ground.
You're such a better lover than my husband. Oh my...
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
Two things here. One, just a legal nicety. The basis of Jim Carrey's original objection was, how do we know that's not the husband? What he's really saying is, you can't authenticate the voices on the tape. It would only be relevant if it's a male voice other than her husband. That's the rule of authentication. Authentication in federal court and every state court is a very low threshold. The question for the judge to decide if it's admissible and authentic is this thing what it purports to be? And there's a lot of wiggle room there, so I think this would have come in. Obviously, they make it comical with her basically admitting that it's not her husband. The other thing I want to point out here is there was once in my career in federal court where I quoted this scene, and I think I even put a link to the YouTube where I was basically saying that this is what happened. The defense was objecting and making a huge mountain out of a molehill, and they had no real objective legal argument. It was just devastating to their case, so I actually quoted this scene. I don't know if that was good or not, but the outcome of the case was ultimately favorable. Thanks for joining in for part one of my analysis of the Liar Liar movie. It's one of my favorites, and I think I'm going to have to come back and do a part two. Maybe we can just, delve into a little bit more of the prenup agreement or the dynamic between all the characters. But for now, hopefully you got a little bit of insight into what's real and what's fiction.